Okay, if you'll give me your attention, we'll get started. Welcome. We're very pleased and honored to have as a guest of our Metro Growth Center, Tom Pelham. Tom is one of the nation's leading planners and lawyers in the land use and growth management field. He was also one of the architects and administrators, implementers of Florida's growth management program, which has been considered, at least until recently, one of the leading programs in the nation and a model for other states. In fact, Tom served as Secretary of the Department of Community Affairs in Florida, which was the highest planning officer and implementer of the growth management program. And that was his big responsibility. Actually, it's interesting because he served in that capacity under two different governors. First, between 1987 and 1991, and then again between 2007 and 2011. I think I got those dates right, Tom. Tom also teaches the land use courses at Florida State University Law School. And he has written very much in the field from the leading publications on smart growth and growth management. So I'm delighted to introduce him. He's going to talk today about Florida growth management, past, present, and future, and how it served as a model for other states, its current status, and of course is going to give us insights into the future, which I'm very eager for. So Tom, welcome to Georgia State, and I'll turn things over to you.
Thank you, Julian. Thank all of you for allowing me to be your guest speaker today. I always look forward to any opportunity to talk about Florida's experiment with planning and growth management. It is an experiment. It has a lengthy history now, 40 years in fact, and for that reason I have notes, so if you see me referring to my notes, it's because the history is so long, there's so many details, and I don't want to leave out anything that's really important. Florida's experiment with growth management is without a doubt the nation's most ambitious, with one exception, that being the state of Oregon, the longest. It was modeled in part after the Oregon program, but in my opinion, the Florida program far exceeded what Oregon attempted until it crashed in 2011, and more about that year a little later. Let me begin at the beginning. In 1972, when Florida was experiencing rapid growth, a severe drought, water shortages, and the burning of the Florida Everglades, literally. That year, Governor Reuben Askew appointed a Blue Ribbon Commission, which was to become the model for Florida's way of addressing these problems. He created a Blue Ribbon Commission to take a look at Florida's situation and what needed to be done to put the state in a better position to address its tremendous growth problems. Out of that commission came recommendations which were enacted by the Florida legislature in 1972. Legislation for state regulation of developments of regional impact and areas of critical state concern, and the establishment of 5 regional water management districts to regulate the way Florida consumes and uses water. There was another piece of legislation that was a part of that package that did not make it in 1972, but it did in 1975. And that was Florida's first local government comprehensive planning act. It took 3 years to get it passed, and that did not happen until 1975. In 1982, 10 years later, then Governor Bob Graham appointed what was known as the Second ELMS Committee, following Governor Askew's First ELMS Committee, another Blue Ribbon Commission. Governor Graham commissioned that body to evaluate how successful Florida's regulations had been in the last 10 years, and to make recommendations for any improvements. And out of that body came what was known as Florida's Growth Management Act, passed in 1985. To give you just a little bit of the background of what the state was facing at that time, and prompted the enactment of this sort of landmark legislation, was Florida's huge growth. It was gaining 300,000 new residents net per year. The state had a growing, tremendous, huge infrastructure deficit, estimated to be about $50 billion just to catch up, and growth that had a huge impact on Florida's environment and natural resources, something that's very important to a state that's surrounded by water on all sides but one. A state that depended upon its natural environment for tourism, a large part of the state's economy. So exactly what did the 1985 Growth Management Act do? Well, first of all, it put planning before regulation. It said, in effect, that before we regulate, we need to have a plan for what we're trying to accomplish. And so it mandated that every local government in Florida adopt a local comprehensive plan. That comprehensive plan was required to be in compliance with state statutory and rule requirements. I like to refer to the Act's major requirements as the 4 C's. The first being compliance with state requirements. The second being consistency. That is, once a local plan was adopted, all land development regulations, all development approvals had to be consistent with the adopted local comprehensive plan. The third C was concurrency. The Act provided that before a local government could issue any development order approving development, there must be in place, concurrent with that approval, the infrastructure that was needed to accommodate that development. And the fourth C, coordination. There was to be planning coordination between the local government and various other local, regional, and state agencies in an effort to make sure that they were all playing off of the same book. In addition to that landmark law, again, that came to be known as Florida's Growth Management Act, the legislature in 1985 also enacted the State and Comprehensive Plan. The State Comprehensive Plan was found in Chapter 187. It was a policy plan that set future directions and goals for the state to meet in various categories. The previous year, in 1984, the legislature had adopted the Regional Planning Act, which had required Florida's 11 regional planning agencies to adopt a regional plan. The local plan was required to be consistent with the regional plan and the state comprehensive plan. These were policy plans. It was a structure which allowed for, and in fact required, state policies on various issues concerning growth and development to be followed, adhered to, implemented by local governments. Each local government, once it had adopted a comprehensive plan or proposed a comprehensive plan, had to submit it to the State Land Planning Agency for its review and approval. The earlier local government comprehensive planning back in 1975 that I mentioned a few minutes earlier did not require state approval of the local plan. And as a result, the local plans adopted under that law never had much effect. In fact, a lot of local governments didn't even bother to enact one since they didn't need state approval anyway. And given that dismal 10-year history with an advisory state role under the 1975 Act, the 1985 Act required transmittal of the plan to the states and a review and approval by the state agency. The legislature was also concerned that these plans be followed, that they be implemented, that they be enforced. And as a result, it created broad standing requirements for Florida citizens. Any citizen with standing could challenge a local comprehensive plan for failure to comply with state requirements, or it could challenge the state land planning agency's decision on the compliance of the plan. It in effect created a new land use cause of action, a cause of action in which citizens with standing could bring suit to challenge these plans to ensure that they did comply with state law. That program, under the 1985 Act, stayed in place, relatively intact, all the way up to 2011. So we had a long period of time, 25 years of experience with that program in which to evaluate the results achieved under that law. Let me just briefly describe what I consider to be the major results of that lengthy experiment with growth management. First, all local governments did in fact eventually adopt a local comprehensive plan that was found to be in compliance with state law. In and of itself, I think that was a major achievement of the law. Prior to the 1985 Act, many local governments were simply not well suited to deal with the tremendous growth and development pressures confronting the state. Many of them not only didn't adopt plans, they didn't even adopt zoning laws. And some major areas of the state did not even have zoning in place. So to reach a result where every local government in Florida, that's about 67 counties and 480 or so municipalities, adopted new plans. I think that was a tremendous achievement under the law. Secondly, this new law, as interpreted by the courts, revolutionized local land use decision-making processes. And I mean revolutionized. Up until that time, zoning and many other forms of land use regulation were deemed to be legislative acts. And you probably are all familiar, I hope, with what a legislative hearing is like before a local government. It's more or less anything goes. Witnesses can say anything they want to. They aren't sworn in. They aren't subject to cross-examination. You don't have to present anything for a record. In other words, the typical legislative process. Well, as interpreted by Florida courts, including the Florida Supreme Court, the consistency requirement of Florida's Growth Management Act changed that. And I think one of the more positive aspects of Florida's history is the important role played by the Florida courts. There was from the beginning strong judicial enforcement of the Growth Management Act and of the consistency requirement in particular. Again, that consistency requirement being that all development approvals, all development had to be consistent with the adopted and state-approved comprehensive plan. Out of that history, we had some very important judicial decisions, one of which is, I think, nationally important. You'll find it in your land use case books. The Snyder decision by the Florida Supreme Court, following the Machado decision by a lower appellate court. In the Machado decision, the question was, is zoning still a legislative act, or has it been transformed in some way by the Growth Management Act? Should there be a different level of judicial review of these decisions under the Growth Management Act than there was under the common law? And in the Machado decision, the Florida Supreme Court and the Florida lower appellate court said, we will strictly scrutinize these local development decisions to make sure that they are consistent with the adopted comprehensive plan. And exactly what does strict scrutiny mean? It means exact adherence to the adopted plan. In other words, the court in Machado said, the local comprehensive plan is the constitution for land use in Florida. When it comes to land use in Florida, the adopted local plan is the constitution. It is now the fundamental law. And zoning and all other forms of land use regulation and development approvals must be consistent with it. The Snyder decision transformed zoning from a legislative act to a quasi-judicial act, with some exceptions. Well, what did that transformation mean? Well, it means that old legislative type hearing that I referred to a minute ago is no longer the rule of the day. If it's a quasi-judicial action, there are certain due process requirements that must be met beyond just notice and hearing. There will be no ex parte communications with the local decision makers before the decision is made. Witnesses will be sworn in. They will be placed and subject to cross-examination. And the person seeking the rezoning change has the duty to make a record by submitting evidence into the record. In other words, these hearings now, under the Growth Management Act, are much different as a result of that act. So when I say the act revolutionized the local land use decision-making process in Florida, that's exactly what I mean, and I think that, in fact, is what happened. It took local governments a while to become comfortable with that new rule. In fact, many of the local governments resisted it. They fought it. They tried to get the state legislature to adopt laws overturning that decision. All of those efforts, for the most part, failed. Eventually, local governments became very comfortable with the new regime, and now it's just embedded in Florida law. Judicial land use decisions and hearings and proceedings are just a part of the standard body of land use law. But it did take a while to get there. What about the performance by the various agencies during this 20 or 25-year period in implementing the Growth Management Act? It's a mixed history. The system certainly has not been perfect. It hasn't worked perfectly. But there were some major shortcomings, I think, both at the state legislative level, at the state executive level. With regard to the legislature, I think the biggest failing has been the failure to provide adequate funding or to provide local governments with additional funding sources to meet the concurrency requirement. Again, what is the concurrency requirement? It's the requirement that says that a local government shall not issue a development order unless there is in existence concurrently with that approval, hence the term concurrency. The necessary infrastructure needed, measured by the level of service standards adopted into the comprehensive plan. Well, that takes money. Who's going to pay the cost of the infrastructure? The legislature, some people think, promised that there would be adequate funding at the time the 1985 Act was adopted. I don't know if that's true or not. It's easy to look back years later and recognize that there's sort of a failure in the system. But it's obvious that to meet the concurrency requirement, you have to have a way of funding the infrastructure. Under Florida's system, 7 or 8 different categories of public facilities were subject to the concurrency requirement. Transportation, primarily roads, potable water, drainage, parks, open space, recreation, being the major ones. So each local plan had to adopt the level of service standard that would be used to measure the adequacy of the public facilities in question. The legislature over the years was very delinquent in providing state funding. But I think an even bigger failure was the legislature's failure to provide local governments with adequate funding sources. And in fact, the legislature tied the hands of local governments in a number of ways. They imposed extra majority requirements or referendum requirements onto the local sales and gas tax options that were available to local governments to raise money. So at the same time the state was imposing the concurrency requirement, it was actually making it more difficult for local governments to meet that requirement by not making available the necessary funds or funding sources. What about the executive branch, the governor? We've had a number of governors during the lengthy history of this process, both Democrats and Republicans. I think it's to be expected that there's going to be different emphasis, different focus about programs like the Growth Management Act. And I don't think that there's any doubt that there has been inconsistent, sometimes indifferent leadership from the governor's office with regards to the implementation of this program. Another failure of the state executive branch is that it frequently itself ignores the principles of the Growth Management Act. While insisting, for example, that local governments comply with the anti-urban sprawl requirements of the Act, the state itself has been guilty of some of the most sprawling development projects imaginable. The one I like to cite the most is that the State Land Planning Agency, the Department of Community Affairs, was given the duty to enforce the urban sprawl requirements of the law. And lo and behold, the legislature appropriates money to support the governor's decision to build out into hinterlands a new state office park, and then it made the Department of Community Affairs move out into this sprawling development, so that the officials at the department had to sit here in the sprawling development preaching to developers and local governments that they had to comply with the urban sprawl requirements. You can point to quite a few other examples of that type. What about the State Land Planning Agency itself? How has it performed during that lengthy period? Well, again, I think the performance has probably been inconsistent, depending in part upon who happened to occupy the governor's office at any given time. Again, the governors we've had prior to 2011 have supported the basic framework of the law. None of them, to my recollection, ever tried to or proposed abolishing any significant part of the law. But the extent of their support certainly varied from time to time during this period. And as a result, because the Department of Community Affairs is an agency directly under the supervision of the governor's attitude is going to have an impact on the way the State Land Planning Agency performed its duties. I think there's no question that at certain times the department was not diligently reviewing all local plan amendments. At times approved far more plan amendments than should have been approved. On the other hand, the State Land Planning Agency certainly stopped a lot of very bad plans and proposed developments over the years. And I could give you a lengthy example of those, just two or three to give you some idea. Again, let me go back to this issue of state review and approval of local plans and local plan amendments. The Growth Management Act itself has statutory criteria that are to be used in reviewing and approving local comprehensive plans. In fact, the legislature also, back in 1985, mandated that the department adopt administrative rules that would set forth minimum requirements for state review of these local plans. It was a rule known as 9J5. And so each amendment that the department received had to be reviewed for compliance with these standards. There were periods of time when the department, some thought, I happen to agree myself, simply was not doing its job. It wasn't reviewing the plans seriously. It approved far too many. But as I say, there's no doubt that it also stops a lot of bad ones. Let me give you some examples of the kind of things that would be proposed by local governments to the State Land Planning Agency. Some of you, no doubt, are familiar with Escambia County, Pensacola Beach, Perdido, and the Florida Panhandle. In 2004 and 2005, that area was decimated by two powerful hurricanes, with great property loss, great damage to the Florida coastal system. Notwithstanding that, 2 or 3 years later, the Escambia County Commission proposed a plan amendment that would have increased the number of residential units in the coastal high hazard zone in Escambia County. A 3,000 residential unit increase, notwithstanding the vulnerability to hurricanes, notwithstanding the recent history. But for the State Land Planning Agency, that would have been approved. The State Land Planning Agency blocked that amendment because, among other things, one of the standards in the Act with regard to treatment of coastal resources and the coastal high hazard area was a requirement that local governments direct development away from the coastal high hazard area, and that local governments not expend any money, any public money, to support new infrastructure in the coastal high hazard zone. That was the basis upon which the State Land Planning Agency rejected those amendments. There are many, many, many other instances of that kind of ill-advised planning that came before the department and was rejected. Nevertheless, in the early 2000s, there was growing sentiment in some parts of the state that the Growth Management Act simply wasn't working, that the State Land Planning Agency wasn't taking it seriously and not doing its job. And out of that came a movement known as hometown democracy. A group of citizens organized to form a petition to amend the Florida Constitution to require that every plan amendment in the state, however small or insignificant, had to be submitted to a public referendum vote before it could become law. Now, probably that law died on the day it was drafted because it was such an extreme reaction to what was a real problem, a bad solution to a real problem. The very notion that a plan amendment to approve a gasoline station on some intersection is not something that needs to get all the way up to the state level or should be submitted to a referendum. Nevertheless, a long, hard, at times vitriolic campaign was waged by those on both sides of the issue leading up to the vote in 2010 on that proposed amendment. The development industry mobilized heavily against it. The Florida Chamber of Commerce ran TV ads describing that it was going to wreck Florida's economy. And then when Florida's economy was wrecked, that it would prevent the recovery of Florida's economy if it passed, that it would lead to chaos, it would be a disaster. And since Florida, by the time the vote took place, was mired in a deep recession, I think that was a message that resonated with a lot of people. Nevertheless, the development and business interests feared this amendment terribly. And in 2008, they had arranged another petition to amend Florida's Constitution, which required a 60% vote of those voting to approve an amendment to the Florida Constitution. They did that to make it even harder to pass the hometown democracy amendment. They need not have worried. The amendment got 61% of the vote against it, so it did not become law. However, in my view, in the view of many other people, it had a very detrimental impact on the Growth Management Act. Because what this proposal did was to prompt a stampede by landowners and local governments all around the state to get their plans amended now, before the voters passed this hometown democracy, which would mean that we have to have the voters' approval of our plan amendment. The State Land Planning Agency was overwhelmed, and I say that, knowing what the situation was. The staff of the State Land Planning Agency had already been reduced almost on an annual basis. It was a small planning agency. It had great difficulty in reviewing every plan amendment, and now it was bombarded with this avalanche of plan amendments from all over the state. And what this did, I think, was to bring home to a lot of people that the plan amendment process is cumbersome. Yes, cumbersome. It can take a lot of time. It can become very contentious, can lead to litigation, and it just began to turn off a lot of people. Landowners who are having trouble getting their plan amendments approved, local governments who wanted to approve a plan amendment, but now we're going to be subject to a vote of the public. I think that undermined public support for the Growth Management Act, took its toll, and we'll see in part what that was in a few moments. I think one of the most praiseworthy aspects of our lengthy history with planning and growth management is the way in which the state legislature and state governors have handled the evaluation and updating of the system about every 10 years. I mentioned earlier that Governor Askew started this tradition by appointing the first ELMS committee. 10 years later, Governor Graham appointed the second ELMS committee. Not waiting for 10 years, Governor Martinez commissioned the Governor's Task Force on Urban Development Patterns, which was designed to recommend ways of dealing with the problem of urban sprawl in Florida. And that Blue Ribbon Commission turned out a report that had a lot of impact, really, on the way we dealt with the urban sprawl issue. In 1992, again 10 years after Governor Graham's ELMS II committee, then Governor Childs appointed the ELMS III committee to do another 10-year evaluation with recommendations for updating the system. 10 years after that, around 2002, then Governor Bush appointed his Growth Management Study Commission. He didn't, I think, use the term ELMS because that's what the Democrats had used. Can't do that, so we'll just call it a Growth Management Study Commission. It evaluated the way things were working and made recommendations, and in fact, two of its recommendations, that Florida mandate school concurrency and water concurrency, was adopted and added to the Act in 2005. Now, what is it about this approach that is significant? Well, first of all, it indicated that the governor of the state thought that planning for our growth and development was important. Important enough to appoint Blue Ribbon gubernatorial commissions to take a look at the system and make recommendations for change. Secondly, in almost every instance, these commissions were given a year, on a couple occasions, I think a year and a half or 2 years, to do their work. The commissions themselves were inclusive. They had representatives of a broad range of stakeholders. They were deliberative. They didn't recommend changes overnight or without careful study and without lots of public involvement in the process. They were open, transparent, encouraged public participation. Hearings were held around the state to receive citizen testimony. They were bipartisan. Members of both parties were appointed to these commissions. So they took the issue seriously. They wanted to make sure that it was fair, that it was representative, and that it wasn't based on anecdotes or what some lobbyist for the development or business interests whispered in the ears of legislators. It was to be done out in the open. That approach was honored by every Florida governor up until 2011 when a new governor took over. In our 2010 election, we had the perfect political storm, especially if you were someone who believed in the importance of sound planning and growth management. We already had a Senate president and a Speaker of the House who proclaimed themselves to be leading the most conservative legislature in the history of Florida, who both were opposed to government in general, planning in particular, and especially Florida's growth management version of planning. In the November 2010 elections, we elected a new governor who rode the tide of the Tea Party movement into the governor's mansion, who openly campaigned during his campaign for governor against the State Land Planning Agency and the Growth Management Act. And lo and behold, he was elected. The perfect storm being that we now had leading the Senate, the House, and in the governor's office, officials who were dedicated to changing drastically the Growth Management Act, if not abolishing it. When I returned to the State Land Planning Agency in early 2007, the then Speaker designate made it clear to me that he was philosophically opposed to the very idea of state review and approval of local government plans, and that it was his desire when he became Speaker, if not before, to eliminate state review of local comprehensive plans and plan amendments. So the supporters of planning and growth management, who certainly, I think, have carried the day for a long, long period of time, now found themselves in a very difficult position. I think a lot of people thought that the new governor would at least take the time to appoint his review commission, because it had been 10 years prior to the Bush. It was now his time to do that. But no, that is not what happened. The Florida Chamber of Commerce seized upon Florida's deep recession, and it was deep, to mount a campaign to eliminate not only Growth Management Act, but a lot of other development regulations. They raised millions of dollars, which they poured into the campaigns of state legislature, Senate, and House, and they carried the day in the election. So, almost immediately after the new governor was sworn in, the work began in the legislature to drastically change, weaken, gut, pick whatever term you want, the Growth Management Act. No gubernatorial commission was appointed. Instead, the legislature allowed lobbyists for the leading development groups and the Chamber of Commerce to rewrite the Growth Management Act. There was no study, there was no deliberation, there was no bipartisanship, there was no open, transparent process. The law was drafted in the back rooms, where most of the legislation in our Florida legislature takes place. I personally witnessed that. I know that's the way it happens. And what was the result of that effort? A radical, unbalanced, poorly vetted rewrite of the Growth Management Act. The legislation dismantled the State Land Planning Agency. It slashed its staff in half, transferred what was left to a new agency called the Department of Economic Opportunity, and made planning the handmaiden, the tool of the economic development planners. But the law did far more than simply dismantle the State Land Planning Agency. I've always thought that that really was a diversionary tactic anyway, that the real goal was to get to the substance of the matter and strengthen the requirements of the weaken the requirements of the Growth Management Act itself. What were some of those things? Well, the Act eliminates many key state planning requirements. Again, let's go back to a point earlier. The Growth Management Act included criteria, standards, which local comprehensive plans had to meet, had to comply with. Some of the most important were plans had to be financially feasible. In other words, you can't slop something down on a piece of paper without regard to the cost of it or whether you can finance it or you're going to have the money to do the things you're promising. You have to demonstrate that it's a financially feasible plan, that either the revenue is on hand or you have available revenue sources that will allow you, the local government, to raise the necessary funds. The 2011 legislature eliminated the financial feasibility requirement. And I might add, it's not really possible to have a concurrency requirement and implement it unless you've got a financial feasibility requirement to go along with it. The Act abolished transportation concurrency as a state planning requirement. It eliminated the requirement that in order to get a plan amendment approved, you have to demonstrate that there is a need for this plan amendment, that there is a need for the additional kind of development that you're proposing. That requirement was eliminated. There had always been a requirement that land use plans can only be amended twice every year. In other words, the local comp plan is important. It should have some stability. We shouldn't be changing it willy-nilly every time you want. Hence, you can only do it twice a year, and that allows twice a year the amendments to be analyzed in terms of their cumulative effect. That requirement was eliminated. I referred earlier to the urban sprawl requirements. That is, Florida should be trying to change its sprawling development patterns. Those requirements were weakened so much that it would be virtually impossible to ever find any local government in violation of those requirements. They're virtually meaningless now. Florida, just a few years earlier, had written into the Growth Management Act requirements that local comprehensive plans should strive to create energy-efficient development patterns and to eliminate greenhouse gases, etc. In other words, climate change and sea level type issues. The 2011 Act eliminated all of those from the Growth Management Act. There are others that I could go on, but I think you get the picture. The 2011 legislature gutted major parts of the Growth Management Act. So when the dust settled on the 2011 legislation, what have we seen? We had seen the hasty, reckless dismantling of about 40 years of work by a long string of governors and legislatures, Democrats and Republicans alike. It almost takes your breath away to see what happened there and how it happened so quickly. I mean, Florida, which had for so many years been the national leader in planning and growth management, has simply almost, you might say, committed planning suicide with this act. With regard to citizen enforcement, which has been relied upon heavily over the years to enforce this act, the new law took the heart out of it. It incorporated into the law procedural requirements that made it very, very difficult for any citizen to ever win any challenge to a local comprehensive plan amendment. So, what does that mean for the future of planning and growth management in Florida? Well, elections matter. That's what we found out in 2010. Elections do matter, and when there's a change in the governor's office, especially, it may mean a change in policy. So, our upcoming November election will have a great influence on what happens in the future in Florida with regard to planning and growth management. The governor who was elected in 2011 is up for re-election, and so it will obviously be a referendum to some extent on his performance and his policies. What are local governments going to do? What is the future of local planning at the local level? Well, many people now see that the best hope for Florida in terms of planning and growth management in the near future lies within the local government. Local governments have home rule powers. They don't need a state act to engage in planning or growth management. But one thing is clear about the 2011 legislation. It intended to send an invitation to local governments. Local governments, we have abolished these planning requirements. We don't think they're important anymore. The state doesn't care. Get the message? You're free to eliminate all of these requirements from your local plans. And in fact, some of that is beginning to happen. Back to Escambia County, which I mentioned earlier, just a few weeks ago, its county commission unanimously voted to direct the county's planning staff to remove everything from the county's comprehensive plan that was not required by the state. My neighboring county, in the county of Leon, there's Wakulla County, a county heavily dependent upon its wetlands, its rivers, its streams, its coast for its economy, just voted to remove all wetlands protections from its comprehensive plan. We no longer have meaningful state review and approval, so there's not a lot the state can do for it. Now, Martin County, down at the other end of the state, on the Atlantic coast, recently exercised its home rule powers and greatly strengthened its comprehensive plan, only to be challenged by large landowners who are now trying to prevent the new plan amendments from taking effect. A lot of what happens in the future will depend on what happens at the local level, at least until the tide is turned by electing a new incumbent to the governor's office that has a different attitude and philosophy about these things. It has been a rather sad experience to hear former governors like Governor Bob Graham talk about how 40 years of hard work have been dismantled in the twinkling of an eye, with no deliberation, with no forethought, simply responding to the desires of key lobbyists in Tallahassee. So I have to say at the moment, at best, the future is very clouded. At worst, you might say there's not a lot of hope until the political climate changes. That will be the key. And I suppose the bottom line message here is to always understand that the planning that we're talking about, is a part of the political process. Planning is politics, hopefully in the best sense of the word. But make no doubt about it, it is contingent upon the politics of the moment, of the year. And I think things may get a little worse in Florida before they get better. Thank you again for your time, your attention, and for having me as your guest.
Thank you very much, Professor Pelham. I think because there are so many classes that are starting early, we won't have a formal question and answer session, but just ask Professor Pelham to stay up front, and if you have a question, then come up and ask it. So thank you again for your attendance. I'm sorry.
Also, there's a sign-in sheet that went around, so make sure you signed in, and if you're a professor in Bergengar's class, make sure you signed in on his sign-in sheet.